Okay, so let me take this time to welcome everybody to our class, and also thank you for your patience in terms of the process that we are engaged in, which is really to talk about this module, human resources management. Yesterday, in chapter 1, we were looking at the role of human resources management at an introductory level, considering also the value that we place upon people as an important asset to achieve the ideals of the knowledge economy, as an important asset to be able to ascertain where we are going in terms of our ideals, not just for the country, but our ideals in terms of the society, in meeting individual needs and individual goals and aspirations. Today, we take a different stance, which is a really, really important facet to issues related to human resources, which is this important aspect of labor, which is the context in which HR happens, which is this labor context that is characterized by challenges, but is also characterized by the need for fairness, equity, and making sure that everybody in this system is actually promoting these ideals of the importance of people in organizations, but considering also factors related to their sustenance. Okay, somebody says they cannot hear what is being said. Yeah, I need that feedback. Do we all hear what is being said?
Yes, Doc.
Yeah, I think that person should
I think she needs to go to her settings.
Yeah. Just explain or join via computer audio and make sure that you join in the audio stream, but the others can hear me. And so we're going to look at legislation, the laws of the country, particularly labor legislation, and how is labor legislation important in inculcating some form of order and discipline to the prevailing status quo sometimes, which is one where there is exploitation, one where there are people who are needing direction and protection from powers that be. And it's this dynamic of power that is always featuring and always important in all of these issues. And when we look at this issue of legislation, we dare not run away from the importance of the Constitution as an important building block towards the preservation of dignity and rights for all. The Constitution is an important framework that instills and makes sure that all labor legislation is rooted and borrowing from these ideals of fairness, equity for all. The overarching means by which the government or the state executes its role and duties is enshrined within this mandate of the Constitution. From all of this, all other legislation appear to stem from and stream from, particularly in the context of work. So the Constitution therefore becomes the supreme law of the country, a supreme law that not only must be respected, but a supreme law that provides guidance to aspects related to the employment relationship. If you like, we can have two types of issues that are at play here. We have the Constitution, but we also have statutory laws or labor laws, as we have come to know them. We also have common law. Common law sometimes dictates that, Numisa, please mute. Common law often dictates that you see a building that we reserve rights of entrance. And so those are the laws that we have. But what we try to teach students here is that these laws are not at competition with each other. but they are really feeding into each other and complementing each other for the benefit of the individual, the organization, and the labor system. So the Constitution guarantees the importance of labor legislation. How does the Constitution do so? Well, the Constitution tries to reduce the spirit of competition and adversary that may exist between actors to the employment relationship. If you like, it is a triangle, and there's the state, there's labor, labor with all its representative bodies, and in the other side we've got the employer, and also the within the context of organization. And all of these are important actors towards the making of this enshrined in the reduction of this adversary spirit, which is basically sometimes viewed to be dysfunctional towards activities that may be at play. So we then extend all of this to tripartisanship, which is this idea that the three of us must get along for the common ideal and the common good. We then extend this idea to cooperation, the cooperative spirit, which is this idea that the three parties must be engaged in a dialogue that allows them to be able to deal with any matters that are counterproductive to the employment relationship. We seek, therefore, to inculcate government's labor market policy. And the labor market policy, I mean, shocking results that have been released today about how the unemployment rate continues to increase. And so the labor market policy that the government adopts should be one really that is pro the movement of goods, pro the protection of those that are less powerful, and encouraging more work to be available and people to be able to enjoy some of these benefits that may exist. We therefore then try through the Constitution to encourage the creation of a labor market policy that is also supported by a centralized bargaining unit. Right now, a hot issue that has been happening a lot is the issue of the negotiations that are happening in the labor market sector. These are negotiations that include issues around wages, to make sure that people are benefiting and to make sure that people are able to have some form of a reference point that allows them to see things for what they are. And an issue which often happens right here with the issues related to labor and legislation is the importance of making sure that we are encouraging all parties to come to the table with a spirit that allows them to be able to see things for who they are. You may be the most beautiful person in the world, but one of the things that you must always remember when we come to this table of negotiation is never come to the table with a fixed position. You may be the most skilled person in the world in these negotiations. Always come to the table having the spirit of saying, I'm going to give, I'm going to take something from this negotiation and the bargaining that happens. So we then try to then make sure that through the constitutional spirit, we comply with the requirements of the Constitution, but also of other related bodies that are encouraging labor. For instance, we will notice another important body, which is the International Labour Organization, the ILO. The ILO is really this representative international body where different stakeholders in countries subscribe to some of its ideals to making sure that there is protection of labor. We then have a streamlined mechanism of dealing with disputes. We know when there is conflict, there must be a channel through which this conflict is addressed. So we can talk about aspects of the Constitution. A question could be asked, what really from the Constitution allows us to be able to link with labor law? So for instance, Section 23 of the Constitution enshrines that every worker or every person engaged in work has a right to fair labor practices. In other words, I cannot just dismiss you from the confines of work. I must have reasonable expectations or reasonable justification why the dismissal is happening. Every worker has a right to join or form a trade union. These principles that you see here would feature directly in labor legislation. And if at best, this shows you the existing linkages that can exist between the Constitution and labor legislation. And we will talk about some of these in chapter 3 and the last chapter when we move on. Say we could go to section 9 of the Constitution, which is the principle of equality before the law. Everybody must have some form of rights that are enshrined to them, the right of protection, the right of the benefit of the law, the protection against direct or indirect discrimination. All of these are things that are featuring in the Employment Equity Act, giving that we must protect employees and also protect employers as well. Section 17 of the Constitution gives us a right of representation around picketing, however is that this is not a unfettered right, as this is also a right that must be interpreted within other legislation. This is the idea of an unfettered right, because it's not an unfettered right. It simply means it must be interpreted in the view of other legislation. In this case, Section 17 is interpreted in line with the Regulations of Gatherings Act. So if you like, you may say, I have a right to walk down the streets of Oxford or King Williamstown or Butterworth or wherever you stay. But your right is not an unfettered right, because the president has announced that we must all wear masks and so forth. So your right must be interpreted in terms of other rights that people might have. And that's also interesting to take into place with what we're talking about. Section 18 again of the Constitution gives employees the irrefutable right to participate in lawful activities. So if it's lawful, it becomes permissible as a guaranteed right, freedom of association, allowing workers to join or form trade unions of their choice, giving a right to aspects related to issues of collective bargaining. So I could ask some questions as we transition. Maybe you can look at some of these questions and tell me what you think. Let's start with the first question. Oh, those are the answers. The first question would read, maybe you can answer true or false. I would like to see the names so that I can call the names. That's the nice part about teaching a small class. The disadvantage is some users here have got usernames which are numbers, so we'll see how that will go. Let's start with Yolanda. Yolanda, in South Africa, all labor legislation are subject to the Constitution. Would you think that's true or false?
True, sir.
That is true. And remember what we say, that the Constitution really gives us the foundation, the bedrock of where we base legislation. Thank you, Yolanda. That's correct. Okay, let's see. Namhla, can the Constitution or a constitutional court overrule the authority of Parliament? So Parliament makes a decision, and then can the Constitution or a constitutional court overrule that decision made by Parliament? Namhla?
Well, I think, Doc, a constitutional court has an overruling power. I'm not sure over Parliament, but I think it's got a higher power.
So the authority of the Parliament is based on its implementing what the Constitution or the Constitution says. So you're actually correct, yes. Glenda, the Constitution is the supreme act of the country.
That's correct, sir. It's the supreme law of the country.
Supreme law of the country. And that is why I love the days of the little constitutional book people work with. I have constitutional rights because they can flag that book as a starting point. Okay, here's another one. Let's take Mandile. Appealing a case starts at the level of the Constitutional Court. Mandile?
I think it's true, Doc.
So if you've got a case, do we start at the level of the Constitutional Court? You have a case with your employer around unfair labor practices. So would you automatically quickly run to your employer or to the Constitutional Court? Remember, what we're promoting is tripartisanship, dealing with issues at a lower level. So what do you think?
No, Doc, I think if you've got an what's the name? If you've got a problem with an employer, you have to first try to resolve the problem with the employer.
That's
and
right.
Then if there is no if you don't reach an agreement with the employer, and then you can go to CCMA.
Exactly. So what we are saying is that ultimately, by the time arrives to the level of a constitutional court, it's a matter of that court using its veracity and interpretation of the matter which is in dispute, and providing a guidance based on what would have been said. Okay, so these are just little snippet questions that we can ask just to keep the class alive. But we go straight into the weightier matters. So the bedrock within the country is the Constitution, but an important piece of document which we need to pay attention to is the contract of employment. The contract of employment is usually a document that is between an employer and an employee to try and allow for some form of negotiation around issues related to accommodating the interests of both parties, which is the employer and the employee. As a result, it is entered legally and it's an enforceable agreement. In other words, we can stand in a court of law with a contract of employment between the two parties as an enforceable agreement in case there's a breach where one can say, no, this other party is in breach of this document. One party therefore places their services at the disposal and control of the other party. This is for an indefinite or a determined period of time. In exchange, this is for a fixed or an ascertainable wage. Okay, we are working for something and you're working according to a period which is indefinite or determined. A contract of employment, as most of you would know, would consist of a range of information. This includes the time, that is time bound. Is it for a 5-year period, 8-year period, 10-year period? It must be permissible by law. So in other words, we cannot agree on something that is not allowed by law and we put it in a contract of employment. An interesting case is if I put you into service as an employee and I ask you to do something which is not permissible by law, that becomes null and void in the sense that what you are being asked to do is something which is not protected by the parameters of the law, and that must be mentioned. So the parties must have legal capacity. In other words, they must have decision-making capability and consent to be able to make decisions which are enshrined within the contract. The employer must also have the power to control the employee and place them at their service or at their disposal. Now, these words seem very like we're using people, but at the disposal really means we must be able to be comfortable to say we are utilizing you for the sake of the work before us. Remuneration must be paid and must be fixed or readily ascertainable. So there must be a determination around what is the amount to be paid for the services rendered. Consensus, therefore, must exist between the parties and the duties, as these are all legally bound. And by this we mean that people must have the right to be able to give and say what they feel about aspects in the contract, and they must also be in agreement. There is no cohesion where somebody is forced to agree with an aspect related to the contract. So an employee, according to the Basic Conditions of Employment Act, Section 83, is really a person who works or renders services to any other person, and this person is presumed until the contrary to be an employee. I'll show you later on a dimension that can also happen of having what we call an independent contractor. The employee's duty is to be, so what we ask, by the way, just to so that we know we have relevant, we can ask you to tell us the duties of an employer, or we can ask you in your assessments to define according to the Act. You do not have to know the specific number to tell me it's Section 83. No, but just tell us what the Basic Conditions of Employment Act says. The duties of an employer, therefore, are to give work to an employee, to put them into service, to provide remuneration where needed, to provide a safe working condition where this person will be able to work, and to make sure there is compliance with any statutory or administrative requirements linked to the aspect of work. And this becomes important because the compliance part is making sure that I may put you into service, but am I also complying with other things like remuneration or other laws that protect the employee when they are put into service by an employer. On the other hand, we have expectations of an employer, an employee rather. We expect them to be put into service. They must give competent service. Interpretation, of course, will allow us to differ on what we mean by incompetence. So if I walk out of my office right now and I see that the cleaner has left a bucket full of water outside, and I quickly rush to think that, well, this is a gross level of incompetence and negligence, really, because this water should have been thrown away. And then I also understand that, oh no, they left that bucket because the ceiling usually leaks, so they want the water when it rains to fall into the... So there is this debate that is expected around what is reasonable service. The person is expected to be honest and faithful. By faithful, we mean that they put in an honest day's work and to the duties that are required for them, lawful duties, that is. So they must be lawful. I could give you an example. The Eastern Cape is this place I hear a lot of stories about in Lusikisiki, where there is a herb that is grown there. So if I am an employer and you are my employee and you drive for me, and then I put in the back of the truck herbs that's of an intoxicating nature, and then I say to you, please take these herbs. Your duty is just to drive and deliver. And right in the middle, as you are going to Lusikisiki, you get stopped. And then they ask you questions to say, we want to search the vehicle. They search the vehicle and they find that you are carrying illegal stuff. The issue therefore then becomes to say, okay, was this person taking part in, were they put into service by the employer rather? Yes. Were they being honest and faithful? Yes, to the best of our knowledge. They were on time delivering the product. But was it a lawful request? No, it was not lawful because it violates the laws of the country. So an employee can actually use that as a point of argument against any form of treatment to say you have not done your duties as you are supposed to. We expect them to conduct themselves in a respectful manner. Again, nebulous and very difficult sometimes to say respectful. Does this mean I have to say good morning, sir, every morning when I come to work? I think the interpretation here could be at least in a collegial manner that allows us to be able to progress with work, to exercise a duty of care that allows for the employer's business, including their promotion of their business to and from, and promoting the best interests of the competing with the employer. And again, this what we are saying here is that employers have got competitors. Your interest should be in promoting the interests of your employer. It will be regarded as not acting in a reasonable honesty to be able to be promoting the interests of the competitor, because you are to be loyal to the person who's put you into service. On the other hand, we have someone who's called an independent contractor. An independent contractor really is a person who undertakes to perform a contract of service as opposed to a contract of work. This person, therefore, is being given the opportunity to be able to put their skills into practice, sign a contract, but have limited rights and limited aspects of enjoyment, which are separate to the work of the other party, in this case, which is the employee. And so they must state what these services are in the contract. They have a method of remuneration, the nature of the arrangement. They may not necessarily work at the premises of the employer. They can have an arrangement as to how they are expected to work and how they're expected to take part in any activity related to the service they're expected to do. A contract, therefore, can be concluded for a specific period of time. It can be agreed and applied in good practice, and the facility to renew this period, this contract of the independent contractor is provided within the ideals of this contract. Concerning remuneration, Section 23 of the Basic Conditions of Employment Act tells us some issues about remuneration. It must be agreed upon, it must be provided, it must be a payment which is calculated with deductions being made. I think when we talk about the chapter on compensation, we talk about the range of deductions that characterize this employer-employee relationship. Sadly, contracts come to an end, and unlike some relationships where they end, somebody was telling me, you know it's over when the person does not return your calls. In the case of the employment relationship, we expect more formality. We don't expect it to be over by you not coming to work, and we then assume that there's been a termination of the employment. So there must be written notice of the termination. It must be given. This happens in the case of these aspects of dismissal, operational requirements, which we'll look at now, and the termination due to incapacity. Termination is defined by law as either of the following. You resign, so you are resigning, which is resigning. You are resigning. Retire, you're no longer in service, or when you die, which is, I guess, a permanent termination of the contract of employment. So an employee is often entitled to a certificate of termination to say the contract is over, here's your certificate of termination. Within the contract of employment, we can even talk about times of work. How much are you expected to work? And this one is interesting because I've been teaching this module for about 8 to 9 years now, 10 years rather. And what you will notice is that this is the very first time or second time we are teaching the module under the happenings of COVID. So sometimes the issue of regulation of work time, we had an agreement sometimes to say we start at this time and end this time. But what you will notice due to issues and challenges of the pandemic, people are working overtime. People are straining themselves. People are working hard to be able to meet objectives. So it's also interesting, the interpretation of this regulation of working time. But working time can be regulated by agreement and in terms of collective agreement, which encompass everybody else, or arbitration awards, which are really out of points of dispute. The maximum ordinary and overtime hours may be regulated by the Minister of Labour in this case, as in section 13 of the basic conditions. Ordinarily, colleagues, we expect you to work not more than 40 hours in a week. I am sure we will complain about this because when we are working from home, but then when we work from home, an interesting dimension is that we have more latitude to take a drive to the garage to get the paper, which you would not ordinarily enjoy when you are in a physical workplace. So we expect 9 hours a day if it's a 5-day working week, or 8 hours in a day where you work more than 5 days, but the 45-hour benchmark must be respected. You may work overtime. You are allowed by agreement, of course, Section 10 of the Basic Conditions of Employment Act. This agreement must therefore then be concluded on the commencement of the employment. So we agree at the start of employment. It's not retrospectively when you then come and say, listen, I've thought about this. I want to go back to that initial whatever arrangement which was there. It must be before the commencement of the arrangement of work. During the first 3 months of employment, and it must lapse within a year, overtime may not be worked in excess of 10 hours a week, or it may not be worked in excess of 10 hours a week. And what we mean here really is to say we must also, people like to work overtime because of the benefits you'll see coming up now, but we must have a parameter of protection also, so that we don't exploit people. Remuneration for overtime is at the rate of 1.5, so it's 1.5. An alternative not less than an employee's wage can be agreed, so it's also open to interpretation there. The employer therefore may grant the employee at least 30 minutes time off on full pay for every 1 hour of overtime worked. And this time off must be taken off within a month of the employee being entitled to it. We can also have something called a compressed working week, where we try to put more hours in a shorter week cycle. The individual or the collective agreements may provide for variation in the daily limits. This enables the working of up to 12 hours in a day, inclusive of things like meals, intervals, like overtime. But the agreement must be in writing and restricted to 45 ordinary hours in any week. So what you notice there as a common feature is this issue of agreement. There must be consultation. There must be a going back and forth that allows the interpretation of some of these things. You can work on Sunday if you want, but it also must be by agreement. It must be paid at 1.5 the wage for each hour worked. When Sundays are not usually worked, it's usually double wage. So, for instance, 48 does not open on a Sunday, and then 48 says to me, Prof, we want you to come to work on a Sunday and do the following A, B, C, D and work. The interpretation there should be, it must be at double the rate of what I usually work for, because it's on a day which I usually do not work. The calculation of ordinary hours, therefore, of work should not take into account time worked on a Sunday, which is not ordinarily work, and that should be interpreted as being separate. We also have some substantive acts or parts of law, and one such is the Employment Equity Act. There are three main issues around these issues of substantive acts. The three main issues that are happening here and at play here are the LRA, the Employment Equity Act, and the Skills Development Act. We will cover the Skills Development Act a little bit later on, but we can talk about the other two, like employment equity. We can talk about the Employment Equity Act and how it seeks to promote equity and affirmative action. So, for instance, the term affirmative action is a term that you will hear a lot which is really a term that has first emerged in the civil rights movement in the United States. Here in South Africa, we started pushing for it when we started the RDP, which is the Reconstruction and Development Program. And significantly and saliently, this term is emboldened within the idea of the Employment Equity Act. The idea really is that this is a labor market policy which is telling us that we have an imperative and a duty to address past imbalances which may have happened at no fault of those who are being discriminated as an important priority in the present day. So there is a difference, therefore, between affirmative action and employment equity. One, affirmative action, looks at issues of the past and seeking to correct those issues. And employment equity, on the other hand, looks at how we promote ideals of the future and how we make sure that we are in a position where we are able to promote these ideals, particularly on issues related to discriminations that are in the present day workplace. So one is framed in the past, addressing the wrongs that they did happen, and the other is making sure that these things don't happen for the sake of the future. Discrimination comes in formats. It can be fair or unfair. What we have here with unfair discrimination is that the Employment Equity Act discriminates against unfair discrimination through race, ethnicity, social origin, color, culture, gender, sex, pregnancy, orientation, disability, HIV status, religion of conscience, belief, and language. We even have some reenactments or revisions of some of these manifestations in present day society. The example can be given here of a private school in Johannesburg, where there is talk about discrimination towards Black students and their hair. So as society evolves, we find even ways in which the discriminator will always try and find a way of upgrading some of these issues at a more different level. And who would have known that we would be having a discussion about discrimination as to Black students here. And I think I find that quite interesting as well. Section 10 of the Employment Equity Act therefore views discrimination along the grounds of it being unfair unless it is established as fair. So the onus and the responsibility of establishment of its veracity, they must be accounted for. So examples of unfair discrimination would be harassment of any kind, medical testing, if not permitted by law. So you come to work and the employer forces everyone, take a drug test, everyone take an emergency COVID test. It must be justified by law. And also issues around psychological testing in some cases, which needs the intervention of the skilled, being people from the Health Professions Council South Africa to be able to identify and pinpoint these discriminations. However, we also have something which is called fair discrimination. Fair discrimination really is also provided within the Act. For example, a company can provide managers with cost to company cell phones or laptops, but not to other employees. And the argument is that these are key personnel in the confines of the work. So that becomes a fair discrimination, but it must be reasonably justified. Definition of designated groups. These are usually defined as Black people, women, people living with disability, and they are onwards known as designated groups. So discrimination can happen. There must be necessity to protect the employee and its applicants. The protection is from direct or indirect unfair discrimination, and this can be through these things we spoke about: race, gender, language, status, health, and so forth. We also have specific duties that accompany these designated groupings. A designated employer, therefore, must employ 50 or more employees. If they employ fewer than that, but they have a total turnover which is above their annual turnover of a small business, they can be classified as designated. Designated could be a municipality. I know we've got a lot of public admin students here who will be au fait with some of these things. It's an organ of state or is bound by collective agreements, appointing it as a designated employer to any provisions that are made. It is in this that we also can talk about then the duties of the employer, which is really to implement affirmative action measures, which is really to make sure that we identify and eliminate any potential barriers that stop the full expression of the employment relationship. It is really to also make sure that we have some form of control as to issues related to aspects of the employer-employee relationship, but also issues related to definitions around what constitutes as reasonable and what does not constitute as reasonable. And the mandate, therefore, is then for us to prioritize those who may have been classified to be designated groups, to prioritize those who may have been classified as previously disadvantaged through their upward mobility in a very segregated workplace. And this is a task that is usually not easy because it is restricted by its nature by impediments that are even prevalent within the workplace itself. We can then talk about what does it mean, therefore, that an employee is suitably qualified. And in this case, suitably qualified could mean things such as attention to formal qualification. It could mean an attention to prior learning, and acknowledged through the range of instruments such as recognition of prior learning, and attention to even aspects related to the experience and the capacity of the person. And this must be something that is not only respected, but taken into consideration as important in the confines of the experience of work. And the ability to be able to do a job and to do the job very well sets up people for this idea of suitably qualified. We also have people, and I think the term there, disabled persons, can be disempowering, but I think we could use terms like people who are living with disabilities. These people who are encouraged to be accommodated reasonably within the workplace, to be included within the work environment, facilities be given to them, the reorganization of work, the training provision, the adequate working time, and provision of specialized supervision that could also allow such people to also enjoy the benefit of work. Recruitment, in this case, covers issues around advertisements and how they manifest. The issue for me is really trying to understand issues related to the detail around the job function, but also being fair in terms of the reach and how much of people we want to particularly target with this application. So the ability of the applicant to perform the essential job functions should be primarily the focus of the work being done through making sure that recruitment and recruitment policies are deemed fair, especially to the range of people. And I think this also covers selection. We've got an entire chapter which talks to selection issues. And for me, selection becomes critical because it talks to not only making sure that we have done a good process of selecting of making sure that we choose from a pool of people the right potential applicant, but making sure that applicant is not impeded by any barriers in transitioning from the selection process to the next process, which is onboarding, making sure that they're part of the organization. Interviews by nature themselves should be cognizant of employment legislation. We do not expect employees to be discriminated, or potential employees to be discriminated by the line of reasoning in terms of the questions. So questions that discriminate, questions that potentially make it difficult for the person to actually have a judgment around the issues that they do. For instance, a no-no question would be, do you intend on falling pregnant? Now think about that. Do you intend on falling pregnant? Now, if you say, yes, I intend on falling pregnant, it could be used as a potential question of discrimination towards you as a person, to say, oh, because you've said you intend on falling pregnant, let's not hire this person. So we must be careful as to the line of questions that we ask and subject potential candidates to. The other issue that we can talk about is the issue of a substantive act. We deviate from employment equity. Now we talk about LRA, the Labor Relations Act, Act 66 of 1995, which is really one of the most popular and common pieces of legislations that we have. The LRA really, it comes about as a result of the history of the country, and part and parcel of the history of the country that we must take cognizance of is how we have come through the pain of the past in terms of the role that labor played, but also looking at the role that the future of this country has been dictated upon by people who would like to take us a little bit further in the work that we are doing in building a very coherent state that is open and accepting of people, despite also the impediments that we have spoken about. So the major actors to the LRA include organized labor. We have our friends, the unions here, business, and other interested parties, could be non-governmental organizations, people who are very, very much a part of the idea of making sure that we allow for expression, in making sure the element of tripartisanship is promoted and given the rightful place that it belongs to. And the rightful place where tripartisanship belongs to in all of this is a place of mutual negotiation, solidarity, and making sure we are also acting in the interest of making sure that the employment relationship does not collapse, but it also is edified by the existence of this collegiality. It applies to all employees, and this includes a range of employees within the workplace. These may be those that were previously excluded, such as domestic workers and agricultural workers. However, the right of this legislation is not conferred to other types of employees. And by this we mean people such as those who are in the defense forces, national intelligence, and you can name them, essential services, who we really must find a way of making sure that they are not only protected, but also because of the nature of the work that they provide for the organization, that they are also seen to be protected, and also seen to be imagine soldiers on strike walking down the streets with guns and so forth. It may not necessarily augur very well with the ideals of promoting the safe interest of the general citizenship, and you would appreciate the sensitivity that this creates. We have the Labor Relations Act for some reasons. We wanted to give effect to Section 27 of the Constitution, which is really this section talking about representation, freedom of association, the rights conferred to joining a union of your own making without being controlled or manipulated to say you cannot associate with so and so. You've got a choice of who you can associate with and work with concerning the work that you do. And one of the things that becomes critical here, at least for me, is the understanding around the issue of collective bargaining, making sure that we create a table where people come to talk about any issues that are affecting the employment relationship and how these issues potentially can serve as important. This platform can serve as an important platform to allow us to vent out and articulate ourselves in points of agreement and even in points of disagreement. The right to strike, the right to employee participation in decision making, and the establishment of forums which are known as workplace forums. So in essence, we've got a range of instruments and activities within the LRA that we must be seen to be promoting, and these include a labor court, a means through which the CCMA, as mentioned earlier on, to solve disputes, a procedure of registering unions and employee organizations, aspects of public law and obligations and how they relate to the Republic, and the way of trying to amend and repeal any laws relating to labor relations and incidental matters that may affect this relationship. And when you look at it, there are two principles that are key in managing these labor relations. The first one is the principle of substantive fairness. Is this for a valid reason? And the second one is the principle of procedural fairness. So how I can illustrate this is that we may catch you stealing at work. And if we catch you stealing at work and then we dismiss you, but in our dismissal, instead of taking procedures of dismissal, we dismiss you immediately. So substantively, you are in violation of, you are basically, you've committed something that you are not allowed to do, in misconduct. However, the process through which we have done in punishing you or remitting some form of justice to this offense has violated the principle of procedural fairness. So whenever we are faced with disputes of a nature of this nature, we must try to strike a balance between substantive fairness and procedural fairness. And this balance is important and critical. Substantive fairness includes, did the employer commit the misconduct? I won't go in depth this because I think this example that I gave you really seeks to explain all of the tenets that I encouraged here. So we have three categories through which we can dismiss you from work. Please pay attention. I always have people at the end of the year come to me and say, listen, I was reading your slides and your slides came in handy when I had my disciplinary hearing at work. And I'll say, okay, so what happened? And they will tell me then some of these issues. The three categories where if you want to be dismissed, it could be through the conduct, your conduct or your behavior. It could be through your ability to be able to take part in the job. It could be through the operational requirements of the business. The first one, the conduct, talks to you as a person. There are clear do's and don'ts at work. And then you violate those do's and don'ts. So your conduct or behavior can become a basis through which you are dismissed. The second one is your capacity as a person. And what do we mean here? Well, The capacity talks about your ability or inability to be able to do the job. The third one could be for operational requirements. Put simply, it could be a case of you are not able to do the job because the business is no longer going to be able to be fully functional and operational. So the dismissal there is a dismissal based on operational requirements of the job. And we're going to look at these. So if you are to be dismissed, has the internal policy been followed? So remember those two principles of conduct, substantively, procedurally. Do you consider the statutory obligations, the instruments where we can say this is where the problem is in terms of the behavior or the lack of behavior around the matter? Consider the codes of good practice, other instruments, contractual and collective agreement obligations. Has there been any precedent that has been set in previous cases? And this is where the work of lawyers comes in to actually determine this. Best practice in allowing us to be able to determine this. But the codes of good practice that we can talk about really the other legislations, because they feed into each other in helping us to understand what needs to be done. And these then provide a basis through which we can understand not only the nature of the dismissal or the potential of the dismissal, but the procedure to be followed there. How is this to be done in an organization? And is there a statement in the organization around all of this, around what is permissible and what is not permissible? For instance, the code of practice for the SABC. The SABC respects the inherent dignity of all South Africans, including those who work for it, and reflects them in their diversity and does not use language or images that convey stereotypical or prejudiced notions. Okay, so that is the code. We do not accept gifts, favors, free travel, special treatment that could compromise our integrity. We respect a legitimate right to privacy. So you could be found guilty for violating a code of practice that is embedded and understood as part of the ethos of that organization. The LRA, the Labor Relations Code of Good Practice on Dismissal, there must be clarity. The code must be accessible. It's not only found in the HR manager's office, but it must be found and readily available to all sorts of people and within the workplace, readily downloadable, if you like, so that it does not create a sense that people did not know what was being dealt with. Consistency in applying the procedure and its implementation. This is the issue of precedence. In the past, how have issues of such conflict been handled amongst actors to the dispute? But we also are faced with something, colleagues, that may be also unfair, which we could call the unfair labor practice. These are acts directly or indirectly which are classified as being unfair. Unfair in this case is conduct by an employer relating to issues of promotion, demotion, or training. You deliberately refuse a set of employees access to training while others enjoy the privilege of the training. So this becomes an unfair labor practice, an unfair suspension, or any other disciplinary action. So the employer's failure to reinstate or reemploy a former employees in terms of a collective agreement. And it's not always easy, as we have said, not always set in stone. It creates its challenges and also issues and matters of interpretation. So employers must therefore be cognizant of the range of challenges that such experiences potentially can create in view of challenges around them. We can also determine then what is the weight of this issue of what's classified to be unfair, the gravity of the offense. Just give me a second. The gravity of the offense, We can consider the nature of the job, mitigating, aggravating circumstances. I responded in a certain way because of the circumstances, excuse me, that were being placed upon me. What does the company policy say? What does the principle of precedence say? The application of the rule as of the past, and driving us into understanding this rule for the present. However, there can be a shorter way, excuse me, if you want to be dismissed. Gross misconduct. So remember, the other aspects were issues that can be viewed from the lens of procedural and substantive fairness. Gross misconduct really does not allow for that. Assault, stealing, actions which endanger the safety of other people. You're working on a factory plant and you leave dangerous chemicals lying around. These issues therefore become issues that can really get you in trouble quickly, and can lead in some cases even to what's called an automatically unfair dismissal. Sometimes these manifest through an employer who dismisses you for participating or supporting in a strike. Well, that violates the principle of association. So it can't be automatically unfair that you are dismissed because of that. You refuse to do the work of an employee who's on strike or has been locked out. You have a right to refuse that because it is not your job. And if you are dismissed, it becomes an automatically unfair dismissal. Exercising any rights in terms of the Labor Relations Act, compelling an employee to accept an employer's demand on a matter of mutual interest, pregnancy, or the intention to fall pregnant. Somebody asks you, do you intend on falling pregnant? Yes. Okay. And then you find out that you did not get the job or the promotion. And so if it can be proven that this intention of falling pregnant is a determining factor to the discrimination, and that behavior is deemed automatically unfair. In a nutshell, what we have tried to do in the past hour is introduce you to three important pieces of legislation: the Employment Equity Act, the Basic Conditions of Employment Act, and also the Labor Relations Act. What you now need to do, and what we are going to do also on Blackboard and also sending to you, especially this group, is you will find we are allowed by publishers to at least photocopy one chapter for the sake of illustration. We don't photocopy books. And I know some of you will have a copy of the textbook on WhatsApp. Please do not send it to the official WhatsApp group of the class. I am not allowed to be allowing such behaviors to be happening. But I will put chapter 2 of labor legislation chapter, because it's remember the 60-40 rule I was talking about. It's a very important chapter in allowing us to be able to understand labor legislation. Tomorrow, we will look at another linked and related chapter, which is the chapter around issues related to the labor legislation system, around unions, why people join unions, the type of unions, the activity base that are surrounded and covered through a union activity amongst members of society. I don't know if there are any questions or comments. Like I said to you, the advantage for me of using this platform is even for those students who are not able to attend the class or even the day group, I am able to put the contents of this class immediately on Blackboard, immediately on YouTube, so that people can be able to watch the content. Don't worry about the assignment. Maybe on Thursday, we'll be talking straight to the issues of the assignment and how you can go about the assignment. Any questions anybody would like to ask before we call it a day? Yeah, students don't ask questions now. They like to ask questions when the assessment is about to come. So I'm sure the questions are on their way, but not now. So we've done chapter 1 of the module, which was yesterday. This is chapter 2, and tomorrow we're going to cover chapter 3. Okay, if there are no questions or further comments, I don't know, Yolanda, you wanted to say something?
Just a thank you, sir. Sorry.
Okay, not a problem. The pleasure is mine. Please keep a watch out. I know some people have been saying they've not received the content. So please drop me an email so that we can just sort out that class email list. And also, I've sent a link for the class WhatsApp group. It's usually a platform, just to converse, and people have got a question or comment. I also extend that, but everything is posted to you. And please keep track. And yeah, I will see you tomorrow. Thank you.
Thank you.
Thanks, sir.